Landlords, there's a chance you're breaking the law without even knowing it. Keep watching and I'll explain how. Do you know how long you're allowed to keep data for? As a landlord, you're duty bound by GDPR and data protection regulations. But, and this is the part most landlords don't realise, you're allowed to keep data for as long as you have a legitimate reason for doing so. Legitimate reasons for landlords are quite strong and include to defend against disrepair claims, responding to investigations, evidence compliance, to show timely actions, protection in deposit disputes, and so on. There's no fixed legal retention period, but the industry standard is 6 years, as this matches the limitation period for most civil claims and protects against claims even years after a tenant has moved out. But remember that once the retention period ends and you no longer have a legitimate reason to keep the data, you should delete it or anonymise it. In other words, remove personal information. You're legally required to keep copies of right to rent documents for at least 12 months after your tenant has left your property. And if someone applies but then doesn't become a tenant, you should delete their personal data immediately unless they've explicitly consented to retain their data, for example on a mailing list. For more information on this, check out the website for the ICO, the Information Commissioner's Office. And as a landlord, if you process data electronically, even just by storing a name and number on your phone, you must register with the ICO and pay an annual fee. That's the part some landlords don't realise and means you're breaking the law.